Good afternoon.
Good afternoon, Madam Chair.
Good afternoon, Senator Kramer. Today is Thursday, March 20th. You were in the Finance Committee. We're going to hear 6 bills today. My Vice Chair Hayes and I are happy to have you with us. We're going to start with House Bill 956, and Delegate C.T. Wilson has sent a representative, so you may come to the table. And I think you have, no, you don't have a panel, do you? It's just you?
No, I do not.
Okay.
It's myself.
Thank you. Thank you for being here.
Thank you kindly. Good afternoon, Madam Chair Bidle. This thing right here? Good afternoon. Good afternoon, Madam Chair Bidle, Vice Chair Hayes, and members of the Senate Finance Committee. For the record, my name is Sharon Lanier. I'm Legislative Director for Chairman C.T. Wilson, and I'm here to, of course, present House Bill 956 to you all, the Work Group on Artificial Intelligence Implementation. I appreciate the opportunity, first of all, and this bill looks to ensure that Maryland takes a proactive approach to AI policy, balancing innovation, consumer protections, and fairness as AI technology evolves. By definition, AI systems make predictions and decisions, while generative AI expands capabilities to create text, images, and code. These advancements present great potential, but also risks, especially in consumer-facing applications. AI is transforming industries, reshaping business operations, decision-making, and consumer experiences. House Bill 956 ensures a well-rounded approach, including representatives from key sectors in the work group on AI implementation, fostering, of course, responsible AI governance. Core sectors affected by AI in this bill that will have representatives will be technology, e-commerce, biotechnology, real estate, healthcare, education, as well as some amendments to come with additional representatives from consumer protection, cybersecurity, privacy, and labor industries. Simply put, this bill establishes the work group to monitor AI regulations and their impact on consumers and businesses, study private sector AI use and identify best practices, review enforcement mechanisms under the Attorney General's office, and develop policy recommendations to ensure responsible AI governance. The impetus for this bill was mirroring Colorado's issues in terms of utilizing a task force to study the ongoing issues in AI governance involving ambiguous definitions, burdens on small businesses, such as navigating unclear AI laws and especially entry barriers, transparency versus trade secrets, and enforcement gaps, ensuring oversight without stifling progress. House Bill 956 positions Maryland as a leader in AI governance, reinforces fairness, innovation, privacy, and accountability. The work group's recommendations are due by July 1st, 2026, and will shape policies that protect consumers, support businesses, and ensure responsible AI use. I request a favorable report, please, and thank you.
Thank you. I was happy to hear you mention Colorado. There's 2 states that have already passed AI bills and 2 states that probably are going to pass it this year. Do you think they'll be looking at what those 4 states have done?
For sure.
Okay, thank you very much. Do I have any questions for Delegate Wilson's representative? I don't see any questions. Thank you very much.
Thank you kindly, Madam Chair.
Thank you. So we have a couple of people. Donna Edwards is here, favorable with amendment, and we have Grace Getty, I think, virtually favorable with amendment. So Donna, would you like to start?
Okay. Good afternoon. I'm Donna Edwards, President of the Maryland State and DC AFL-CIO. Thank you, Madam Chair, Mr. Vice Chair, and members of the committee. We submitted testimony with amendments with support. I'm glad to hear from the sponsor that they'd already read some of those and added. But we do have some really severe questions about AI, and we've been before you on an AI hearing that significantly made changes to the bill that was before you. So our questions really came up at, the members of the committee. And as you all know, AI is not new. It's as old as I am. And it's just like in the last decade, it kind of just evolved, and now it's exploded. So we do need to get our wrap around this. But in looking at the task force or the group, we have e-commerce, and you don't have the retail industry. You have biotech, but you don't have cybersecurity. You have real estate, but you don't have insurance. And the first 2 things talk about in the impact of the livelihood on people, which is their work, and the second one is the deployer and developer of obligations related to labor and employment. So labor is not even represented on this task force. We would also say that the task force shouldn't start at the beginning. We think that you should start where you've been and look at all of the laws that you've already had to analyze the legislation considered during 2022, 23, 24, and now 25. You've had bills before you, and bring that all together. I think the most important thing is not to have this driven by any one industry or any one consumer, and to definitely add workers, because workers are the ones that are going to be more impacted than anyone else. And we always have to remember that the critical understanding of AI is that the algorithms are based on humans inputting the data. And it's just like Senator Ellis said, what was true 50 years ago is still true, garbage in, garbage out. And so we do have to have a responsible avenue, whether it's this bill or another, that really looks at what Maryland's going to do to provide guardrails for workers and consumers and all of our residents. I thank you very much.
Thank you. Do I have any questions for this witness? Senator Lamb?
A quick question for you as follow-up. I'm looking at your testimony. You had some specific suggestions of additional people to the work group. At least looking at the prior versions, doesn't look like it had changed since introduction.
It didn't. Right? We provided testimony in the House, but they were not accept. The amendments didn't come over.
Okay, so nothing was added to the work group. Okay.
And this isn't I would suggest that this is not the end all of what we're suggesting.
Right.
Probably not.
Probably not. Thank you very much. I didn't call John Fiastro. John, you're sitting way back in the corner. You want to come up also? We're going to hear from the virtual witness, and then we'll come back. So, Grace, you want to unmute and give us your testimony?
Absolutely. Thank you, Chair. Honorable Chair and Vice Chair and members of the committee, I'm Grace Getty, a policy analyst at Consumer Reports, where I focus on consumer protection issues in artificial intelligence. Consumer Reports, if you haven't heard of it, it's a nonpartisan nonprofit with 6 million members across the country. We're known for testing vacuums and washing machines, but we also advocate for consumers' interests. And I have real concerns about the makeup of the working group before us. The working group is tasked with a gravely important subject, quote, the regulation of artificial intelligence used in decisions that significantly impact the livelihoods and opportunities of individuals in the state. This is a huge topic. We know that AI is being used for hiring, firing, deciding who's selected for rental apartments, background checks, and more. It's playing a critical role in the fates of Marylanders in a way that intersects with consumer protection laws, employment law, civil rights, and more. And yet, while the working group is further directed to contemplate consumer rights, employment rights, and privacy rights, those voices are nowhere to be found in this working group. There are 3 representatives of the real estate community, but 0 representatives of consumer protection interests. There are 3 representatives of e-commerce, but 0 spots for people with expertise in civil rights, 0 spots for privacy advocates, and 0 representation of labor interests. Such a lopsided group is sure to generate recommendations that work well for businesses, but those recommendations won't have everyday Marylanders in mind. I submitted a series of amendments to the committee in writing via a coalition of public interest groups that would rectify the makeup of this working group, and I strongly encourage the committee to not move forward with this bill without making significant changes to the makeup of this working group. I just want to say I also served on Colorado's task force that was referenced earlier, and that task force was much, much more representative than the one you have before you today. So with that, I'm happy to take any questions.
Do we have any questions for Grace? We'll look at that task force for Colorado. Thank you for that information. I don't see any other questions. John Fiastro?
Thank you, Madam Chair, members of the committee. My name is John Fiastro. I'm here on behalf of my client, Cybersecurity Association of Maryland. My comments today echo some of the testimony that you've just heard. My client would be very much interested in having representatives from the association, the cybersecurity industry, added to the task force. It would be appropriate as AI is being used more and more to facilitate cybersecurity attacks, and it's appropriate to have cybersecurity professionals on the panel. I do recognize that work groups need to work efficiently, and while my testimony suggests that my written testimony on behalf of my client, suggests that we are offering 3 members. If we do increase the size, each industry currently in the version of the bill that you have before you has 3. You might want to clip the individual industries representative number down to 2 so you can accommodate this larger size. But with that, thank you, Madam Chair, and we urge a favorable report with an amendment.
Thank you, John. And Grace's testimony in her written testimony suggests that, reducing those 3 representatives to 2 and then adding additional industry. So thank you for that. Any other questions? Senator Reedy.
Thank you, Madam Chair. And I wonder if I could ask Donna just a question quickly. I know we've joked sometimes about me being a friend of labor, friend of the working man. But the truth is, I think there's a really interesting conversation happening nationally across party lines about the role of AI and automation and workers. So, for example, truck drivers. If we could one day have automated trucks going everywhere, there's a societal cost to that if we put largely men that are ages 35 through 50 out of work. So I think, I'm glad you're here to talk about this. I mean, I think, is that part of the concern? Is if anything we're talking about with AI and the workforce needs to include labor representatives?
Part of the concern is what jobs will be replaced or totally removed, the danger to society when that happens, if we have all of these unpersoned, I won't say unmanned vehicles. But other things, I can just
Apologies.
give you, a real example. I've been asked in the last few weeks, why is labor so involved in this? One of the really important parts is that some of this is being used in how do you relate in client services. And in California, in retail, hospitality, they're literally looking at facial expressions as you interact. And those facial expressions are you smiling? Are your eyes wide open? We all have different faces, but if that algorithm is based on one particular societal group, then others of us, if you're heavier, your eyes may actually squint when you smile. So you look like you're frowning. And these are things that are used against workers. And so the biases and what can be built into it. And again, it is simply learning each time it's collecting data. And it becomes more biased, and that's why you have to do the testing, and why we were so adamant in the other bills about having third-party testing for biases, because this is going to impact all of our lives.
Thank you very much.
Thank you.
See, any other questions for this panel? Thank you both very much for your suggestions. We do have 2 unfavorables virtually. We'll start with Ben Winters, I think. Is that Ben, you want to unmute and give us your testimony?
Great, thank you. Hi, Vice Chair, Chair and Vice Chair and members of the committee. Thank you so much for allowing me to testify virtually today. My name is Ben Winters. I am the Director of AI and Privacy at the Consumer Federation of America. Consumer Federation of America is an association of hundreds of nonprofits that work to do research and advocacy in the interest of everyday consumers. So first off, just want to express my gratitude for the committee to be thinking about this issue at all, but also express the fact that we are way beyond working groups and task forces. Task forces have been being made for at least about 7 or 8 years, and we know a lot about the use of AI. But if we are going to take the route of not passing meaningful AI regulation, but rather doing a work group or a task force, the makeup of the work group or task force as written is absolutely unacceptable and will not lead to equitable outcomes for Marylanders or accurate outcomes where we know about the studies of the labor impacts, the discrimination impacts, the accuracy impacts, the manipulation impacts, without representations of groups that focus on privacy, that groups that focus on consumer protection, focus on labor, academics that study and understand how these AI systems work. There is really no reason to do that, right? You're just going to get a business-friendly outcome and kick the can down the road on real meaningful AI regulation. So for that reason, I oppose this bill, but if it is to be moved forward, the makeup of it needs to be drastically changed. We give specific recommendations in a letter sent to your committee early this morning. This was from a coalition of several national as well as Maryland focus groups that agree with us on this point. Thank you so much.
Thank you. Do I have any questions for Ben Winters? I don't see any questions. Thank you. Now we have Kara Williams. Hi, Kara.
Hi. Thank you, Chair and members of the committee. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent, nonpartisan nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. And we've been before this committee before talking about AI this session. So I'm glad to be back. I'm here today in respectful opposition to HB 956. While a working group to study AI can be a positive step, establishing an AI working group cannot be the only action that Maryland takes this session to regulate AI. AI systems have well-documented histories of inaccuracy and discrimination, and these unproven discriminatory systems are already being used to harm your constituents. Marylanders urgently need you to address these harms, and passing a working group only bill will only delay policy action that is urgently needed. If the legislature ultimately feels that a working group is necessary, I'll echo the points that earlier panelists made, as well as the points that are in the written testimony they mentioned. But a working group must be paired with substantive policy action to protect Marylanders from these ongoing AI harms. And if you do choose to move forward with this working group, EPIC wants to express that the working group structure composition laid out in this bill is woefully insufficient and fails to include many of the most important AI stakeholders. As you've heard, there are many industry representatives, but there are absolutely no representatives from labor unions, from civil rights, consumer protection or privacy orgs, from academics with expertise in AI, or technologists. These public interest entities and experts should all have a voice in any Maryland AI working group. Failing to include these representatives who focus on protecting the rights of all Marylanders, especially the marginalized communities that are most harmed by AI's discrimination, will create an unbalanced and one-sided working group that would have an insurmountable bias against any meaningful regulation of AI. For these reasons, we urge an unfavorable report on this bill. Thank you.
Thank you, Kara. Do I have any questions for Kara? I don't see any questions. Thank you for your suggestions.
Thank you.
That ends the hearing on House Bill 956. And now we're going to go to House Bill 372. It's Prince George's County delegation, and Delegate Ivy's here.
Hello.
Delegate Ivy.
Good afternoon, everyone. Madam Chair, Mr.
Will you pull the microphone close?
sorry.
Thank you.
Good afternoon, Madam Chair, Mr. Vice Chair, and members of the committee. My name is Paul Andrews, and I'm here on behalf of Delegate Julian Ivy to present House Bill 372. This is a local bill which passed out of the Prince George's County House delegation, as well as the House of Delegates, with a vote of 135 to 2. It removes a sunset provision for this local development authority so that their good work can continue. Thank you all for your time today, and we're asking for a favorable report on House Bill 372.
Well, thank you very much. Paul, do I have any questions? You have questions? Do you? Oh, he's going to take your picture. Okay. This is not Delegate Ivy. I don't have any other witnesses. It was, this is a sponsor only, so thank you for your testimony.
Thank you all.
That ends the hearing on House Bill 372. And now we're going to do House Bill 664, and I think Brooke Scoville's here for Delegate Jen Teresa.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Brooke Scoville, Chief of Staff for Delegate Jen Teresa. Thank you for the opportunity to present HB 664, which is a cleanup bill requested by the Board of Nursing. In a nutshell, what this bill does is make sure the board has the same disciplinary authority for all professions under its jurisdiction. Here's a little background. In 2014, the General Assembly passed HB 908, which expanded the board's disciplinary authority to allow it to grant licenses that were subject to reprimand, probation, or suspension to applicants who had in some way violated the Nurse Practice Act before the license had been granted. Before this bill was passed, the board's only available action was to deny a candidate a license, or deny a candidate license. This meant that the licensee pool was smaller and punished folks beyond what was really necessary. Since the passage of the 2014 bill, licensed direct entry midwives were added to the board's regulated occupations, but the disciplinary provisions were not included in their statutes. So this bill simply matches the disciplinary language in the LDEM statute to that of all other professions under the board's jurisdiction. Note there's a simple amendment to this bill which would align HB 644 to SB 854, another bill about direct entry midwives, which the Senate already approved, and its cross-file also passed the House. I respectfully urge a favorable report of HB 664.
Thank you. Do I have any questions for Brooks? I don't see any questions. Thank you for your testimony.
Great, thank you.
That ends the hearing on House Bill 664. And now we're going to go to House Bill 1210, Delegate Susan McComas. She's not arrived yet. Okay.
She should be on her way.
Do we want to give her just a minute? Are you author? You can come to the table. Is Christine Crone here? Christine, you can come up. I really would like the delegate to introduce her own bill, so let's give her just a couple minutes. Because you said she's on her way over?
I have to call. I talked to Darlene a little
Okay.
while ago. She said she knew it was to be around 1:40, 1:45.
Okay. How's it going? Okay, so we should go ahead. Okay. Christine, you want to have a seat and author? She's actually in voting appropriations on the budget, so we're going to allow you to present the bill, and if she comes in later, we'll give her time.
Okay.
Thank you.
Should I just start, or?
You can start.
Okay. All right. My name is Arthur Flax. I'm a licensed.
Mr. Flack, sit down. Pull the microphone
Oh, I'm
close.
sorry, ma'am.
Get comfortable.
Yeah,
We're
okay.
here.
I'm sorry about that.
That's okay. Thank you.
My name is Arthur Flax. I'm a licensed certified social worker clinical. I have a diplomat in clinical social work. I want to thank the committee for the opportunity to present information today. I submitted written testimony which goes into the legal definitions and reasons that support this bill. You will hear testimony today, I believe, from the opposition, which will be misleading and confabulated, as it was in the House hearing. The licensed certified social worker clinical is a separate license. That licensee has the authority, the legal authority, to evaluate, diagnose, and treat mental and emotional disorders, conditions, and impairments. And as such, I have been registered with the commission for many years, and I used to receive work from the commission directly to evaluate people. I worked with both claimants' attorneys and defense attorneys, including Sims, Bowen, and Sims, on a case years ago. It was because, in that case, when it turned out that the claimant's attorney had referred a client to a psychiatrist who was overprescribing medication, and we summoned that this commissioner summoned that psychiatrist in, at my opinion, at my request, as a witness of fact, not to show his records, not as an expert witness. That psychiatrist dismissed that patient immediately, and then noted to the commission that since I was not listed as a physician, that my testimony would not be acceptable. And that's how this began, because at that point, we looked at this situation because the commission can do it. And I do have an AG's opinion on that from Kathy Rowe in 2005 that said the commission can accept us, but we're not able to because we're not listed under 9721 of the Labor and Employment article.
Good afternoon, Senate Finance Committee. My name is Christine Crone, here on behalf of the Greater Washington Society for Clinical Social Work, here to testify in strong support of House Bill 1210. House Bill 1210 would authorize licensed certified social workers clinical I'll refer to them as LCSWCs in the rest of my testimony, to conduct evaluations for permanent mental or behavioral impairment in workers' compensation cases. LCSWCs play a critical role in mental and behavioral health care in Maryland. Under the Maryland Health Occupations article, LCSWCs are recognized as highly trained professionals with expertise to diagnose and treat mental health conditions. Pulled directly from the statute, it says, for an individual licensed as a certified social worker clinical, practice of social work also includes evaluation, diagnosis, and treatment of biopsychosocial conditions, mental and emotional conditions and impairments like that with the Workers' Compensation Commission, and behavioral health disorders, including substance use disorders, addictive disorders, and mental disorders. Furthermore, LCSWCs are well-versed in utilizing the American Medical Association guides to the evaluation of permanent impairment, which is a standardized framework for determining the extent of these impairments. And with that testimony, I urge a favorable report. Thank you.
Thank you. Christine, one question. LCSWC, they have passed an exam and can work with people one-on-one, unsupervised, correct?
Correct. They actually are the licensure level that supervises the other social workers.
I just want to be sure I understood.
Correct.
Do I have any other questions for this panel? Senator Lamb.
Yeah, thank you, Madam Chair. Just looking at some of the testimony that's in the bill folder here, there's a contention from some of the opposition that if LCSWCs are able to perform ratings, that it might not be upheld at the appellate level. Do you have any sense of?
I can try to answer that, sir. I'm a qualified expert witness in the Maryland District Court, Maryland Circuit Courts, and the U.S. District Court for the Fourth Circuit. My cases have been upheld. I've testified in various areas of mental health, not necessarily just workers' comp, but mental health, mental disorders.
So the contention here is that that's not the case.
I know, that's what I said before. You're going to hear misleading testimony.
Okay.
They've also grouped all social workers together using the word social workers. Licensed certified social worker clinical, as the chairwoman pointed out, is a separate license. We have the authority to, the same as a psychologist. A psychologist is not does not practice medicine. A psychologist is a medical professional, healthcare professional, the same as we are.
Okay. Thank you.
Thank you. Thank you, Senator. I don't see any other questions. Thank you both for this testimony. We do have two unfavorables that will come up, Carmen D'Alessandro and Michael Daly.
Thank you, Madam Chair. Mr. Vice Chair, members of the committee, for the record, my name is Carmine D'Alessandro, representing Chesapeake Insurance Employers Company and the Injured Workers Insurance Fund, here to respectfully oppose House Bill 1210. I did not have the opportunity to testify across the street, so welcome the opportunity today. First, this is not about opposing a licensed clinical social worker clinical from treating, from counseling. This bill has one thing. It's about whether they can use this book promulgated by the AMA to perform impairment ratings for the commission. This book is replete with references to physicians conducting these impairment ratings. This is the 4th edition that Maryland uses now. They're up to the 6th edition. In the 5th edition, it specifically says these ratings must be conducted by a psychiatrist. So we feel this bill is putting the cart before the horse. If there's going to be a change, the medical community should make that change in the book, and then the statute will catch up to it. I don't know if it was in written testimony on our part, Senator Lamb. We are very concerned that if this statute is changed, that means the impairment ratings can be submitted to the commission. But if those cases are appealed to judge and jury, this book will be used to disqualify those opinions based on the fact that they're not recognized as experts by the AMA for the sole purpose of performing these ratings. We feel it'll lead to much more motion practice, much more appellate practice, and in the end, it will be the injured workers who, if those opinions are disqualified, the injured workers will not have an opinion because the insurance carriers will be using a psychiatrist. So for those reasons, we respectfully oppose House Bill 1210.
Thank you. Michael Daly?
Thank you, Madam Chair, Mr. Vice Chair, members of the committee. The Maryland Defense Council, who I'm here representing today, respectfully ask for an unfavorable report on this bill. We certainly share the same concerns that Mr. D'Alessandro raised. As it pertains to the qualifications, and let me just join in on one aspect of this. We absolutely support clinical social workers' abilities to treat patients. In fact, we supported prior versions of a bill that specifically referenced that. Social workers certainly are qualified and trained to evaluate and help folks that have certain conditions that require their expertise. What this bill, we believe, causes an unintentional problems on is the impairment ratings that the American Medical Association guides to permanent impairment specifically limit those evaluations to be performed by physicians, psychiatrists, and psychologists. Our statute says the same thing, not only in the section here that this pertains to, but also the Code of Maryland. The commission is empowered to regulate and come up with regulations that work so that the commission system works. And those impairment evaluations are limited to be performed solely by physicians, psychiatrists, and psychologists when it comes to mental illness and disease. What happens in a case, as Mr. D'Alessandro referenced, if it gets appealed to the circuit court, either party can appeal, and the issue involves that permanent impairment finding by the commission. Under the Daubert decision, which is the most recent appellate decision in Maryland courts, adopted that in determining whether or not an expert's qualified to testify. A social worker, clinical social worker, would not have the medical qualifications to testify under that standard imposed by the courts. For those reasons, we respectfully request an unfavorable report.
Senator Lamb?
Thank you, Madam Chair. I guess to follow up on that line of questioning from the earlier panel, so your contention is that if this were brought to the courts because LCSWCs are not in the AMA manual, that it would throw their impairment rating into question based on their expertise? Is that?
If I was trying a case at the circuit court, Senator Lamb, I would move to strike the opinion based on it not being an expert qualified opinion, and I would rely on the AMA guidelines that talk about psychiatrists and physicians. Now, do I know how a judge is going to rule? Obviously not, but I can, in all these cases, that would be the motion that would be filed in every case. And if those motions were upheld, then the injured worker would be at the appellate level with no expert testimony whatsoever, and then would most likely.
How often have you found those to be upheld?
Well, we've never.
You've never.
We've never right now, as the gentleman indicated, only a psychiatrist or psychologist could give the rating. So that has not happened. There are no ratings that I'm aware of in the commission system that's being performed by licensed social worker clinical at present.
But haven't LCSWCs been testifying all the time under Daubert?
They could testify as to their counseling, their treatment. It's just this, what this impairment rating is basically a doctor assesses percentages. There'll be multiple percentages that are presented to the trier of fact. Those percentages equate to then a number of weeks of disability, and those weeks of disability equate to monetary contribution from each week. So they can testify in certain areas, absolutely. We're talking about one specific area where you go into this book and develop an impairment rating, and that's where the book narrows it down to a certain group of people. So I'm not saying they can't testify on other issues, it's just this one specific issue.
Right, so the AMA's opinion on expertise could be considered by a judge, right? Who should be able to testify and be able to give a evaluation of impairment, I guess, right?
Correct.
But it's ultimately a court's decision. It's the judge's decision who they would be willing to accept, or what testimony they'd be willing to accept.
Right, and that's what I said. I can't tell you how those motions would be ruled upon. I just tell you those motions will be filed. Obviously, I don't know how an individual judge in any circuit court would rule. Obviously, it's never come up yet.
Okay, thank you.
Thank you. Senator Ellis?
Thank you, Madam Chair. Questions, Mr. Alessandro. So you picked up that book and you say, that governs what the judge look at. So I went and picked up this book right here from up there, and the law book. So if we put this bill in this book, doesn't this govern what the judge have to rule on with that book?
Senator Ellis, I don't think so, because the medicine, I think it should be the other way around. I don't think that because a statute has changed necessarily means a medical opinion is going to change. And again, I'll give an extreme example just to make my point, and this is not to make sarcastic or anything like that. You could put in the book that physical therapist in the workers' compensation system.
Which book you talking about? That book or
well,
this
in
book?
that book.
This
you
book,
could,
okay.
you could put
The
in the,
law book.
in the Workers' Compensation Act that a physical therapist in the workers' compensation space can perform ankle surgeries. Put it in there. I don't think any hospital is going to allow that to happen because the medicine clearly is going to refute that. I'm just saying that it should start here before it gets to there. That's my opinion.
But I mean, you're complaining the issues. We're talking about who can testify and be credible. Now, who does medical procedures? I mean, those are two different things. Like
I understand, but you still have
apples and
to
oranges.
You still have to be qualified as an expert. So any expert that testifies first has to be qualified, and that's where I think because of what's in here, there will not be a qualification.
Okay, so qualification, is it based on credentials, experience? How do you define qualified?
So, for example, in the 5th edition, it says who should perform the report, what specialty a psychiatrist should. So if you're taking, there's a place in the book about spine injuries, then it's going to say who should, a spine surgeon, oral surgery, they'll talk about a dentist. So each section of the book that talks about a specific impairment will talk about the medical discipline that should be giving the opinion.
Okay, thanks.
Thank you.
Thank you, Madam Chair.
Any other questions for this panel? Seeing no questions, that ends the hearing on House Bill 1210. We have a sponsor only on House Bill 848. I think we have a representative here from Chair Pena-Melnick. This is health insurance adverse decisions, notices of reporting and examinations, and we have heard the Senate bill. And are they in the same posture? Are they in the same posture? Okay. Oh.
Good afternoon, Chair Baidu, Vice Chair, other members of the committee. My name is Emmanuel Animashan. I'm a staff of Delegate Pena-Melnick, and I'm here on our behalf to introduce House Bill 848. It's Health Insurance Adverse Decisions, Notices, Reporting and Examinations Bill. The bill basically seeks to protect Maryland health insurance consumers by expanding the required content of the quarterly appeals and grievances report that each carrier must submit to insurance commissioner. Basically, if the number of adverse decisions issued by a carrier for a type of service has grown by 10% or more in the immediately preceding year, or by 25% or more in the immediately preceding 3 years, the carrier must include a description of those changes in medical management that might lead to the adverse decisions, as well as any other reasons that are known, or a description of the carrier's efforts and actions taken to determine the reason for the increase. This bill is in the same posture with the Senate bill, except for an amendment that's been made at the House, which requires private review agents to have a phone number and an email address dedicated strictly to utilization review and separate from the general service line, with capabilities to respond within 2 business days. With that, I am happy to take questions. Otherwise, I ask for a favorable report on House Bill 848.
Thank you for your testimony. Do I have any questions? I think the committee's going to have to work and get the two bills in the same posture because they're not at this point, but we'll work on doing that. Thank you very much for your testimony.
Thank you,
Are you going to
Madam Chair.
continue with the next one, Preserve Telehealth? Is that yours?
No, that's not mine.
So that
Someone
ends the
there.
hearing on House Bill 848.
Yes.
Now we have House Bill 869.
869, yeah. Thank you.
Thank you. Is anyone here for 869? There we go. I was going to present it if you weren't here, so thank you.
Good afternoon. Good afternoon, Madam Chair, Vice Chair, honorable members of the committee. My name is Boluwatife Aderomo. I'm a physician and a master's in public health candidate at the Johns Hopkins Bloomberg School of Public Health. I'm here on behalf of Delegate Peña-Melnick in support of the House Bill 869, Preserve Telehealth Access Act of 2025. This bill would permanently extend critical telehealth provisions set to expire in 2025. This bill is in the same posture as Senate Bill 372, with the exception of one amendment, which seeks to repeal the prohibition of healthcare practitioners prescribing certain controlled dangerous substances for the treatment of pain through telehealth. And this is because we believe that by repealing this part of the article would help to improve access to pain management for patients, especially patients with chronic pain, and this would ensure that these patients who potentially face barriers in person visits would not have issues with long travel distances, limited mobility due to their condition, lack of transportation, and time constraints due to work and or family obligations. And based on this, it's also important to know that by repealing this prohibition, it does not mean that we are removing all the safeguards. It means that that some of these substances are still subject to federal and state regulations, and this will ensure that patient safety remains a priority. I'm happy to take questions. Otherwise, I ask for a favorable report on this bill. Thank you.
Thank you for your testimony. We're going to hear from a couple other people. The difference between the Senate bill that was voted out and the House bill, there's a study, but there's also to allow opioids to be prescribed by telemedicine. So we're going to hear from Jen Witten and Helen Hughes next. Thank you.
Thank you.
Thank you for your testimony.
Good afternoon, Madam Chair, Vice Chair, and committee members. For the record, Jennifer Witten here on behalf of LifeBridge Health. First, I just want to appreciate the committee's consideration for the years of support in expanding and adopting policies that support the use of telehealth. As you know, during COVID, it was a critical tool for us to deliver care. And since then, we've added provisions to expand that and address some of the parity issues. So the bill as passed from the Senate is a crucial bill. As you heard, it's going to sunset in June, and we definitely want to be able to continue that. What I would speak to is the prescribing amendment that we talked and were discussed over in the House. Really, our intent there is, like many other states, they have the allowance for prescribing with established patients to manage pain. So you're going to hear from Dr. Hughes several examples of these patients that we work with that need that ongoing management. Prescribing controlled substances is regulated by a number of different entities. The DEA, in particular, at the federal level, had issued guidance around allowing prescribing. So for Medicare patients, this is allowed. We anticipate final regulations to be issued this year. In addition, here in Maryland, you've all passed pretty strenuous laws that require providers to obviously have their license as a provider. You also have to file and be licensed under OCSA, which is an agency that oversees all controlled substances. As a provider, you also have to use the PDMP. when prescribing to not only look at what's been prescribed here in Maryland, but also in other states. So there are a number of different agencies and oversight that can really look at guiding that. And this to us is really about an access issue. Again, we appreciate the committee's consideration for this amendment. We know that HEAU has had some concerns, and in all fairness, the amendment discussion happened very quickly in the House. We have since had a discussion with them about what our intent was here. So appreciate the consideration and happy to have any discussions or further information for the committee. Thank you.
Thank you, Jen. Dr. Hughes.
Yes, thank you so much, Madam Chair, Vice Chair, members of the committee. My name is Helen Hughes. I'm a physician at Johns Hopkins. I'm a pediatrician. I lead our telemedicine office, which oversees telemedicine across adult and pediatrics, our 6 hospitals and ambulatory sites. Very, very grateful for all the support with PTAA, and it's been a game changer for our patients, but wanted to speak specifically to the Controlled Substance Amendment. We're really seeking here to align us with the national flexibilities that we currently have and will be in place when the DEA finalizes its new rules, as well as what we see in our peer states, Virginia, DC, Pennsylvania, Delaware. I spoke with one of our palliative care doctors yesterday just to get a sense of real world impact, and he spoke of a mid-30s cancer patient, a mother who has metastatic bone disease. She has terrible pain. She lives 1 hour away, and wondering, is the state's intention really to require her to come in monthly to get an opioid prescription every 30 days when she has a metastatic terminal cancer? Other conditions, sickle cell disease, hospice, and I know there are concerns about bad actors, but I would think that those bad actors, their behavior would already be addressed based on current Maryland law. If I was to hang out a shingle and start talking to patients over the phone who I had no relationship with and prescribing them opioids, I think the medical community would definitely see that as not the standard of care, and that would already violate Maryland law. So our hope is that in passing this amendment and this bill as it stands, that we would allow Marylanders to have the same care, that 35-year-old cancer patient, if she lived in Virginia, she wouldn't have to come in to have those palliative care pain visits monthly. So on behalf of Johns Hopkins, we urge a favorable report on HB 869 as amended. Thanks so much.
Senator Lamb.
Thank you, Madam Chair. Just looking through the bill folder here, I guess, Ms. Whitten, you referenced the Attorney General's Health Education Advocacy Unit. So it looks like they're still, I guess they're primarily opposed to that provision, right, with the substance use, or the substance, sorry, the Schedule II controlled substances prescribing ability through telemedicine. They contend that it's not narrow enough. What's kind of your response to that?
Sure, thank you, Senator, and really good question. And I just want to publicly acknowledge that things happened very quickly at the House, and we were not able to have some of these discussions. So we recently met with HEAU and their team to further describe what we were really intending to do here. And I think that they appreciated the focus on these existing patient relationships. And I think the key for them is really having that, what we would say, like a bona fide relationship with their provider. And I think Dr. Hughes just spoke to that. We talked about clinical standards and some of the oversight and the sharing of the information. We'd be very open to talk about if there's an ability to make that stronger in the amendment. Again, it was written in a way that just removed that prohibition. So we're open to that and appreciate their role and understand we want to make sure that we're supporting clinicians and those who don't follow Maryland laws are held to that accountability.
Yeah, it just seems like the OAG, and I know the HEAU and other offices within OAG seem generally pretty conservative, reticent about these abilities and whatnot, whether it's this bill or other bills when it comes to this, maybe sometimes overly so. Have you seen in other states any issues with prescribing Schedule II by telemedicine?
Not that I'm aware of. I'm part of the ATA Clinician Council, American Telemedicine Association, and they have an advocacy group that works in states. I know Georgia had proposed within the last couple of years a restriction on controlled substance prescribing via telehealth, which actually they were able to get kind of rescinded, and that ultimately was not passed. So I'm not aware of other states passing new legislation to address this issue. which makes me think it is not an overwhelming issue for other states. I think most people are focused on following what the DEA plans to do, which is to have a special registration, so an additional registration for those who will have more scrutiny if they're prescribing controlled substances via telehealth.
Got it. What about a possibility of, if there was a need to have to limit it, that you could do Schedule II prescribing, but it would have to include some video interaction by telehealth versus I guess this would be open to audio only as currently drafted?
Yes, I would be open to that. I think it's always best to me when we can leave it to the patient and the clinician and that individual decision. Let's say it's a sickle cell patient. We have evidence that patients over 65 in East Baltimore, 50% of those are counter and audio only. If you have a sickle cell patient, you have established relationship, it's a Friday afternoon, they're having a pain crisis. It's their typical pain crisis. Is it reasonable for that prescriber to prescribe over the telephone? I think many clinicians would say probably, if that avoids an ED visit in a patient with an established condition. So I guess my preference would be to kind of have clinicians use their judgment based on what's the standard of care and triage. But I certainly understand that's a possibility. I'm not aware of any states that require video. Virginia requires a bona fide relationship, but that doesn't mean that that's not the case. We could certainly look into that.
Okay. I'm not saying that, I think we have to have video. I think the important part of the history here, because I was on Education, Health, and Environmental Affairs before when this bill was originally passed, was that this bill was passed without any limitations the first time, and it was only a floor amendment that came in because telehealth was so new that actually placed some limitations on Schedule II specifically. But if you were to look back before COVID, before the pandemic, the federal government did allow Schedule II drugs to be prescribed by telehealth as long as the patient had been seen once by that provider. So
Yes.
there was a lot more flexibility there.
And that's true
it
for
seems
the
like now
currently
there's less.
proposed registration only applies if there's no established relationship. If you have an established relationship, you can do unlimited prescribing by any modality, which again, there are laws that would preclude you from doing it in an inappropriate way. But the federal guidance only applies to new patients. So this is quite much more restrictive than the federal guidance.
Right. Okay, thank you.
Thank you, Senator. So, Doctor, my question is, I'm kind of reading the amendment here. Does the bill now require a bona fide relationship, or can it be to anyone?
It does not. It strikes it says to follow state and federal guidance, which the federal guidance, if what's proposed passes, would be that for an established relationship, you can prescribe as if you were in person, if you think it's clinically appropriate. If there's no established relationship, you have to have a special registration, an additional, above and beyond a DEA, above and beyond a CDS, you have to have an additional registration to do it. So that's what's currently proposed.
And that's what the bill says now?
The bill says now that you should follow all federal and state laws related to controlled substance prescribing.
Okay, thank you for that.
Madam Chair, if I may, just real quick, in previous legislation that we've passed and in the current regulations as it relates to all telehealth, digital delivery, you have to have a provider-patient relationship, and that's enumerated by a number of requirements that you have to meet. So you have to have the intent, you have to get consent, you have to verify, you have to document. So that's enumerated in the current regulations based on legislation that's passed in years before.
I see the amendment refers to a part of the COVID regulation, but I just don't have that in front of me right now. So thank you for clarifying that. Do I have any other questions for this panel? All right, I think that ends the hearing on House Bill 869 and ends our hearing for today. Thank you very much. And stay around because we are going to get ready for voting. And everybody's here.